one thing we forgot is the planning board.
Oh, yes.
That Ron will take care of that at the planning board hearing, so.
Yeah.
Okay, so we're fine with that. Okay,
All right.
all right, folks.
Now that we've had that very fun.
You're gonna reappoint this guy and you're not gonna need me anymore.
I don't have to appoint him.
Oh, that's true.
He is inherently
You're
present.
unappointed.
I therefore release you from durance of aisle and. Okay, you guys are on.
Yay.
We do, I mean.
Do you need one?
No, we have plenty. Not yet, because we used them all.
Not that I know of.
I'm not sure what this, I have not seen, I didn't open this.
What? We said the summary, not the exhibits.
Okay.
So. Second, we're gonna get a little organized here. Okay, so you have, this is now convening a rehearing of the Lyme Pinnacle Project rehearing. And if I am reading this correctly, or perceiving it correctly, this is your new submission package for the complete rehearing.
Correct.
So we're starting from ground zero.
My understanding, yes.
Okay, so that's,
That's fine.
I don't think we are starting from ground zero to the extent that any evidence that came in before is still is relevant for what we decide. Because it's part of our record.
It's right here.
This is on their motion for reconsideration.
Right.
And if it's not part of the record, then I'm gonna move that it be. That is, we have a whole bunch of evidence beyond what they're offering, which we considered as part of the original motion. And that needs to be part of what we talk about.
Is this a rehearing or is this a new hearing?
this is a rehearing.
Okay.
No, it's part of the record.
I
Okay.
believe it is part of the record. I suspect we will find as we review this, that there's a substantial recapitulation of prior information. And the other document which was sent to us, which I hope you have copies of for us, is a email that came in this afternoon.
That is the summary in the notebook,
Okay, so.
without the exhibits. My understanding, and I've actually been through this both ways, the request for a rehearing gets granted or not. Technically, this is a new hearing. And so I have had some communities, and the ruling has been that this is a new record. The board gets to make a new decision. Information that was previously provided can be incorporated by reference. But the issue, kind of like an evidentiary issue, if previous information isn't resubmitted, there's an argument that it can be excluded. And I've actually been through it both ways. Some towns say, you cannot rely on anything that was previously submitted, and they hold me to that rule, meaning it's not here, it's not part of the new record.
What objection would you have for us considering all the evidence that came in from other parties as well as ourselves in the prior hearing?
I don't have an objection. I think it's up to this board to determine how it wants to define the record. I would only ask that there be some specificity as to what is being considered. If the board decides to dip back into the other record, that it be clear, that we know what the board's considering.
Well, go ahead. yeah.
Let me ask
Probably
one more
gonna say
question.
the same
Yeah.
We had to do a very lengthy finding of facts based on the record that we had before. What you are seeming to suggest is that we're gonna have to do the same thing. And I'm wondering about that.
like I said, I've been through rehearings where the four corners of that rehearing are what's before the board, because the decision was made that that's out, now we're back for a new hearing.
And we had 6 hearings.
I know.
Okay,
Okay.
let's cut to the chase here. My feeling, which I throw out for comment to all, is that were materials presented in the first set of hearings due to public comment, which may be part of our deliberations. And so that if we wish to include those as a part of a finding of fact, we do so in open meeting, so that you have a chance to comment on them. And this is gonna kick us back and forth between deliberation and comment on a number of occasions. But that way, this material exists in the past and was submitted as a legitimate part of a hearing. And we're not gonna get much public comment coming in now, from what I can see. Well, there don't seem very many people in the room. But what would cause them to come, Walter? Unless,
It was renoticed, is my understanding.
it's been renoticed.
Right.
This was
it's
a
re-
request for rehearing, which we're gonna say in a few minutes, yes or no.
No, we've passed, no, this is the rehearing.
Do you think this is?
This is the rehearing.
Okay,
That
then
was
I
my
have-
understanding.
No, that's my understanding also. We
I would have-
deferred the rehearing until this date,
Mhm.
I
and
would
then have the option of hearing some things tonight and then continuing it. And then we can request additional evidence. We can say that we wish to place in the record of the new hearing evidence from the past hearings, one way or another.
I would have a couple of questions.
Sure,
Real
Bill.
quick. We were mailed something
July
earlier.
22nd.
Yeah,
It's
July
dated
22nd.
July 22nd. Does that have any bearing on tonight?
She's
My
claiming,
understanding and the way it's been, my experience is no. That is our request for rehearing that I understand was
which has
granted.
been granted.
Yeah.
Those were points of error we believe were made during the last process. Therefore, the board's prerogative is to say, no, we stand on our decision, or, okay, do-over. There were
This is
errors
the
made or
do-over.
not, this is the do-over.
All right.
And that's why, again, my experience, like Donovan, town council and I for a million years, makes it very clear. The only thing that comes in at a rehearing is what's presented during the rehearing.
So my question is then, do you have a different plan than what was submitted originally?
No, because that's the one thing that remains the same.
It cannot
It's
be
not a
changed.
new
It's
application.
not a new
Thank you.
application.
That's-
It cannot be changed.
I didn't know
Right.
exactly what vocabulary to use.
Right, it's a rehearing of the old application.
So this July 22nd was your request and the rationale
Yes.
for asking for a rehearing, not
That's right.
necessarily
Right,
the information you wished us to consider now that we've granted the rehearing.
correct,
Okay.
correct.
That works for
Um,
Yeah, that's what I thought we were going to be doing.
Yeah,
So I have a question. You said that this is the same plan because it's the same application. Does that mean the dimensions, locations, numbers, all the data submitted, the drawings showing locations and building size and all that stuff, prices, have those changed or are they part of this package? Are the drawings identical,
the plan, yes, the plan is the same.
the plan?
Okay.
Well, the plan is,
The application is the same, and the
so it's the same
application,
same number of buildings, same locations, road locations are the same.
if you look at tab
Well,
one,
I haven't looked at it, I'm just
I know.
asking the question.
our consulting engineers, CLD, submitted with the application the calculations and the plan. So that, at tab one, is the same.
So we have a specific set of drawings that you've identified that are now part of this hearing.
And in tab two, we have the pictorial, the zoning board, not planning board, so we have the pictorial representation. And at tab 5A, we have the architectural schematics.
And
But
those-
are the, may we then include by reference the large drawings that we had previously?
And specifically which set, because I think they changed.
That I agree with you, Walter.
Yeah.
So that
Would be an
fundamentally,
issue
we
for me.
need to bring in, if those of us who've retained it, were they aluminum, no, they were bigger than they
They were big.
They
They were
were
big.
big,
It's 36 by 24.
There was a large set of plans
The 36
submitted with the application.
Yeah, okay, but those are substantially identical with the plans that we have in our possession.
You had, not with this, the original plans are still the same.
This as an example.
Well, are they identified in this package? Do you have those drawings in there?
No, what's identified here is the ZBA application.
What we need is, because we will need these in order to create our findings, we will need, either, go ahead, Walter.
Yeah, I mean, maybe this is an issue among us for discussion as to what we need, but I'd move to require that all prior information become part of the record for this application. And that when specific drawings, data, or other information that is contained in the old set differs or similar to this set, you'll identify which is the valid set of stuff that we're supposed to be looking at.
Yeah, I would say the same.
Okay, I'm in substantial agreement with you.
Maybe that's an issue for us to vote on, but that's.
Yeah, what I'd like to do is take a minute, if you don't mind, and go into deliberation and discuss this, because I think we're probably at a level of technicality where we shouldn't be in a question period on that, with current material.
I have one more question.
Sure.
There's a fair amount of data that Pinnacle submitted supplementally, such as the information on the financials, et cetera, which aren't in here.
Correct.
So you've got stuff that you are not resubmitting, plus
Correct.
the other materials. Okay.
My understanding, again, on a rehearing, and frankly, given the history, we have, in essence, boiled the presentation down. There was a lot of requested information. There was a lot that was not part of our original presentation. There were a lot of detours that we took in response to questions, which arguably had some or maybe tangential relevance to the specific zoning variance questions that are before the board. And this happens a lot. Boards move into site plan issues, et cetera. So we have provided the information, not a new set of plans, but the application and the information that we believe is most relevant to our request for a variance.
So
Yeah.
technically speaking, and this can be addressed as an open question, we should then be going back to the Conservation Commission and telling, either saying, we're putting their previous findings into the record, or you guys gotta go out and do it again.
Yeah.
I disagree with that, and that, the Conservation Commission has reviewed the
But
application.
that's prior.
It's the same application.
No, yeah, but no, you
By
see,
record.
this isn't, then we have to include it by reference.
And it can, that was my point. If you want to include something by reference,
Otherwise, we have to do it all
correct,
again.
you can send us back out to the Conservation
Right.
Commission.
Yeah.
But we need to be specific as to what's being,
So basically,
Included by
Bobby,
reference.
in all, if we come back to you at the next meeting, because I want to limit this tonight before, I don't want to get at 9 o'clock at night, because I'm just back from China, and I'm not sure which time zone I'm in. Data, we say, these documents in front of us, so you may inspect them, we wish to include by reference.
I move we go into deliberation. I think this is an issue we have to decide for
Okay,
ourselves
fine with
first.
you all, let's do it.
Yeah.
All in favor?
Aye.
Aye,
Aye.
usual rules apply. Walter?
Okay, so we have a package that nobody's had a chance to look at. It's only slightly smaller than all the packages we have to date. I've already found that there's things in it that I'm gonna ask for more data on.
Mm-hmm.
Maybe the easiest thing to do to reduce the total chaos that this might evolve to is to cherry pick each piece of data as we uncover it in this new presentation and request specific input in terms of whether it's conservation report, whether it's drawings, whether it's prices, anything else that we find we need in order to evaluate
I
the
think you're
application.
correct, Walter, I think that's
But-
procedurally very clean to do that.
Yeah, except that, what that effectively does is it may eliminate important information that showed up in the past.
Well, my concern is to get the input of public comment, which I think will be, unless,
Well, let's identify sections, let's identify sections of prior testimony
But,
that
you
maybe
know,
not.
their request and the information they're providing here sets out specific places where they disagree with our decision.
Here,
That's yeah.
in this thing?
Yeah, page number 3, for example.
Oh, I haven't read it, so.
Well, I'm just reading it myself, but I just
Okay.
take page 3 in the middle. Variance request number 1 is not contrary to public interest. I assume if I read further, that it would explain why they think it is not contrary to the public interest.
Yeah,
Okay, so either we rebut their new assertion
yeah.
and move on and just reaffirm our first decision, or we say, you know what, we didn't really talk about that very well. Let's go ahead and add some additional paragraphs or sentences to our original decision memorandum
Mhm.
under this section and so forth. I don't see, if otherwise, if we don't do it this way, I think we're starting from ground zero and gonna go through the ordinance page by page, to arrive at substantially, well, I'm prejudging here obviously, but we're gonna arrive at a conclusion that is gonna be this thick, when actually we only need to address the things that they say we screwed up on.
well, I
They
mean,
don't, as I read this, they have not stated in here anything that we've screwed up on, that they say we've screwed up.
no, that's
They are-
there.
And that's supposed to be
It's null and void now,
Irrelevant.
irrelevant now, although there's
what
one
they're,
section
what
of
they're,
it.
what they're saying in this document, although I haven't read it,
Yeah.
is only that they are submitting X number of variances, and they're describing for each of those variances the reasons why they should be granted.
You will find that's a rehash in the entirety of this
Right.
document.
Yeah, of the reason for the request for rehearing.
This being,
Yeah,
Yeah, I mean,
Okay.
the arguments as to where we have erred are the same.
The arguments may be, but the
No,
statements.
no, the statements are.
So it's just a copy of that
No,
letter?
No, it's
they're
a
asking for a
restatement,
procedure,
so that
different
it's no
procedure.
longer reads quite like a bill of attainder.
so
Then I
From a
move to
procedural
adjourn
point
until
of
we have a
view.
chance to read this stuff.
You're damn right.
So as a procedural matter, we're going to review our original decision, given any new information that's in addition to what we looked at previously. Right, taking, I would assume, special attention to the reasons they laid out for their request for the rehearing. And address those points that way and see where we end up. Or, even though it's the same application, are we essentially starting a review of their application from scratch?
I think it's a strange hybrid of both, to be honest.
Well, I would
I don't
say
see how we can unread what we have read.
I'm personally I'm not interested in rehashing everything.
Me neither.
And I would like to take.
I think we have to treat them with utter fairness in this thing and go through it if we have to, bit by bit by
Well, I
bit.
don't mind going through it, but what I really would like to do is address the request for the rehearing.
That's been addressed.
It's been addressed, because we've granted the rehearing.
Yeah, but not because of any specific thing, we just said, yes, okay, we're gonna grant you the rehearing. We didn't agree to any particular item.
We agreed to nothing, we didn't make a decision about any of these things. We said the grounds set forth raised enough points so that a thorough review of our findings
Yes,
is appropriate to treat the applicant with complete fairness.
yeah, all of that being true, the things that have been raised where.
Must be, I can't avoid reading the two of them.
Yeah, I'd rather read this one first, frankly, because that's the one that lays out their criteria for our failure. Well, maybe that's a poor choice of words. It lays out the justification where we missed out.
For the request.
So I don't really wanna go back and talk about how many angels there are in the head of a pin if it's not relevant to the rehearing. The rehearing is only the things that they say where we made a mistake.
They're taking the position, if I look at this document correctly, and I think Walter's point's a good one here, that we really need to read this and come back before, but that fundamentally, these are the clear statement of intent here. This is their goals, and these are our questions. They want us to come with an open mind and look at this and say, this is what we're up to.
It's the same application, isn't it, though?
But it's the same application.
Well, then I don't see what we have to read everything over again.
Well, that's, the only reason that we have to read everything over again comes as we form findings. Because this is the document we must use to inform our findings
This time around.
this time
Are
around.
you sure?
I don't think so.
Well, unless,
Are you sure?
wait a second, no, let me qualify this, Walter. Unless we then by reference go in and say, we have found this in the prior documentation, and therefore are including it in our current findings by reference, and here it is on the table.
I mean, if they submitted a plan and we had hearings on that plan and certain information was brought forward, certain testimony was taken, so forth, so on, are we to ignore all of that?
No, my feeling is we may bring that in by reference, and Bobby's been clear on that. That fundamentally, this goes town by town, and I think what we want to vote to do is we say, we may include prior information by reference as long as the applicant has an opportunity to challenge any factual material
Sure,
contained in that.
Absolutely, yeah, no question.
And so that treats them completely fairness, but does not force us to forget the past.
Okay, so my
Because I
question-
want to make very certain
What I'm-
that
what I'm-
public comment
what I'm
is
looking-
appropriately included in this, because it's both pro and con.
So if it's the same application,
Yes.
are we to understand that there's new information?
I have no idea,
And what do we
but
do?
they, in the rehearing, my feeling is, because I was gonna ask for it, that they could add new data pertinent to said application. But it's only if it's pertinent, provably pertinent to that application.
So, I have two suggestions, and let's give this package to the town attorney. And ask him for a ruling on what we are bound to, how we are bound to conduct a rehearing,
Yes.
what information we can or are bound to consider, so we don't get ourselves in a situation that we don't understand, and we're behaving without the ramifications.
Well, we're behaving logically, but not
And then-
properly.
So that's one suggestion, then the second suggestion, we adjourn, so we can get the information back from the attorney and give each of us who have
Like
time and interest to do so, a chance to read through this stuff and start to formulate some opinions about whether it is gonna be an easy haul or a tough haul or something.
I mean, some of these documents, and you're just by the date on them, I'm gonna assume, I'm gonna find them in other three reclaimers.
You are.
So, again, it's the same submission, same plan, same supporting information.
Well, yeah, and my main question is, are there any differences?
That's what I was hoping there'd be an index that would show new submissions or something, not just resubmittal or something already
I have
considered.
a horrible feeling that we really need to review this in pretty great detail. And then I want to bring in the full-scale plans, Conservation Commission's finding, because we have to have that, we can't proceed without it.
Yeah.
And public comment, and then get agreement from all parties as to what the public comment means, because one of the things that was here was whether there was bias in our treatment of public comment, and I want to address that directly.
I have another thing that I'd like to request from the applicant, since we have this,
We need to do that in question.
no, I want
Yeah,
to discuss it
agreed
in
now, yeah.
deliberation first. I'd like to have the applicant, ask the applicant to identify any of the information in here that has not been previously submitted.
I agree completely.
So they could delineate that information, give us an index of it, so if it's all been done before, then it makes life a lot easier. If there's new stuff, we know where to look and what the differences are, and
We go from
consider
there.
that, so they can give us that index.
Good, I think
Would
that's a
you-
very,
Are you amenable to having council give us some guidance on?
as I am, sir, completely.
I've looked at the RSA, I don't, I'm not guided by it.
No, I think we definitely want that.
Seems very rarely that the RSA really guides anybody on anything.
I wanna make sure that there's.
Or you'll find out how it guided you after some court has decided.
Yeah, right.
Okay, so,
There's
I
another,
think,
one more comment.
certainly,
So to the extent that we wish to have the prior record enhanced beyond what's here, it is going to impose the burden, I guess, on us to identify what those exhibits were and what the documents were.
Yeah.
it does, and I think we just have to do that as
And
part of
we have to do that.
our diligence, that's the way life is.
But that affects the timetable. of
Let me
everything.
make sure I understand what you're saying, just because it's slightly different than I think what I was requesting.
It is.
I was requesting that they supply
Yes,
an index of differences between today and before.
I agree with that too.
But our due diligence is to identify from the prior submittals which of those,
Which non-pinnacle things are not in here? Which other pieces of evidence that came in from any other party, or that came in from ourselves, or whatever, is then in the record?
For
We have to
example,
identify what those are.
do you think we have to do that carte blanche, or do we do it as we encounter questions we might
we
have?
have to do it both ways.
So my understanding and my guess is what council is doing is trying to set the record for an appeal, and I wanna make sure that everything's in the record to be there.
Okay.
It's all,
And,
so,
Okay.
for example, the whole bunch of maps we provided of adjacent properties,
yeah.
which are going to be very relevant to a determination of the uniqueness of the given property.
Yeah.
We have to have those in the record. So we fundamentally
Yeah.
do
Okay,
a
so-
combination of, which fortunately you all can hear what we're saying. We fundamentally saying, tell us what is new in this.
Mm-hmm.
And then we're going to come back at our next meeting, having our members made a review of this document to the degree to which they feel able, and then
Having legal counsel.
having
Reaction.
legal counsel's reaction, and then having a pile of paper that we will bring, or that I will undertake to bring. And I want to find out right now, because there's a question here, once we go out of deliberation, that I'm going to bring up. How to do this in a way which doesn't violate the public meeting law.
Yeah, I agree.
What do you mean?
Because as soon as we're out of deliberation, I can talk about, let me say this. I need a method of getting data from every one of you into David, so we're not communicating inappropriately, but we're still, Bill says, I want this, Rob says, I want this, you say, I want this. And so then either you or I can then forward those materials so that there's a stack of them waiting to be put into evidence at the beginning of our next hearing. Because I'd really like to try and get this into a package as quickly as possible.
is there,
Well, we can all,
any reason not to just say that all of the materials submitted previously in conjunction with all of the hearings is part of the record? And then we'll refer to them as we need to in our decision.
If council agrees to that.
that's where I
I
started.
would rather,
Yeah,
I
if
would
council
rather
agrees
have
to that.
the
Then we can
freedom to
cherry
pick
pick
and
what we
choose.
have to.
Exactly,
Right.
but what I wanna make sure is that once we've used something, it's put on the table.
Oh, yeah. No, I think, but I don't know that I wanna be restricted between now and the next meeting to figure out
Right,
which
because this
pieces
is,
of the prior
Agreed.
record.
this is gonna go a couple
Uh,
of hearings, and we're gonna have questions, and we're gonna
Well,
surface
also,
new material.
I think also, and I'll bring this up in just a minute, we will find that we're going to do all of our deliberations and findings of fact in public. And,
Sure.
Yeah.
which we
in
did
public.
last time, but we also did individual writing assignments. And there was, in section,
Oh, yeah.
I'll deal with this shortly.
All right.
Okay,
Sure, but
Well,
are you comfortable with just saying as a blanket rule, we're going to incorporate?
if council agrees, I'm comfortable with that.
I wanna move it now.
Okay,
I wanna move that all the prior documents and materials that were submitted at the prior hearing be incorporated in reference in the record.
Second.
all in favor?
Aye.
Okay.
And now the burden's on us to
make
identify
use of
what
them.
those are, but.
To
Identify them and
identify
then
it.
to bring them out so that they then become record of the rehearing. Now, I want to transfer them formally from point A to point B.
Yeah.
Okay,
Um,
fine.
Okay, so with that in hand, shall we leave deliberation?
I shall move.
Second?
Second.
All in favor? Aye. Okay, so part of what's driving us here, guys, is your point 4 in your July 22nd memorandum. And we made a very, very serious attempt to be very public and very open about all of our procedures, and I'm wondering why that paragraph's there.
I'm lost.
As well as the last
Roll
It's
paragraph.
on page 6.
As well as the last,
Page 6
last
of
paragraph
the
of the
July
submission.
letter.
Oh, I don't have that. Or I don't have, wait a minute, I do have that.
Yeah.
That's the one that
And
David sent me today.
Right.
July 22 letter,
Yeah,
page 6.
page 6.
This is the inference that we have not complied with the open of a meeting law, and that we may have done some things off the record. And
Board-
I personally find that offensive, but I'd like to hear what the basis for your
You wanna read it
notion
again?
was.
No,
Okay.
I'm not sure it's appropriate at this hearing, which is a rehearing, to address this point. Certainly, no offense was intended, but there were, it appeared to us, I think the letter speaks for itself, it appeared to us that there were preconceived notions brought to the table, and I think the letter
please
speaks for
expand on
itself.
that, Bobby. I will
But
be-
again, I really don't want to get into, I don't think this is fair, and I don't think it is reasonable to get into this discussion at a rehearing.
It's fair because we have tried to run with reasonably informal procedures while adhering to the letter as we understand it of the ordinance, but trying to do this in a very open and very collegial manner. And what has been suggested here is that we have failed. And if we have failed, we want to know the specifics of where this failure is perceived. Because quite frankly, I don't like adversarial procedures. And this creates an aura of adversary, and it has to be disposed of.
Well, and again, I don't think this is the appropriate forum.
But then there is none, you're saying.
At this scheduled rehearing for this application, I don't think this is an appropriate discussion.
Then where would you think it appropriate?
Please go.
I wanna inject two things. First off, I wanna make a representation that there was never any meeting, other than the meetings that we had here, that constituted a public meeting. Secondly, that every one of us who drafted a provision did not consult with one another. Now, if there's something beyond those things that happen, we don't think it happened, but I'd like to hear what it is.
Exactly, that's why we're. asking
Secondly,
this.
it is a matter of the hearing, the way you have phrased this last page of what you've done here, claiming that we're biased. Claiming that both the planning board and the zoning board is hostile to the applicant. We might be unhappy with council, we're not hostile to the applicant. And I say that as a professional, similar profession.
The legal ongoing obligation, and I will address this, it's in our rehearing application. Planning and zoning authorities do have, Supreme Court has said, an obligation to work in good faith with the applicant. This applicant's been dealing with the planning board, not this board, for a good long time. At what I thought was a very positive suggestion, that work has tried to continue over the past few months. It's being met with unfortunate inflexibility and again, sort of a moving of the goalpost, if you will. The Carbonell case talks about, oh, here's a proposal, what do you think? Oh, I don't know, come back and give us another one. Oh, well, here's one, what do you think? There needs to be some honest discourse, and this isn't this board, I'm talking about the
Your
planning board.
language says it, let me read your language.
Right.
Outright bias from the town, both the planning board and the zoning board.
Yes.
You wanna retract
And
those words?
certainly, well, again, I
As to the
don't
zoning
think
board?
that's an appropriate request, but some of the commentary, even at this board, was definitely hostile, has been tonight in a way, in
Yeah.
terms of demeaning or degrading what the applicant's trying to put forward.
How? Please tell us, Bobby, I'm very curious about it, I don't understand where you're coming from.
I don't see it either.
I don't see it.
Um,
We have really busted our tails to try and treat Pinnacle Project with utter, complete fairness. And I think that the videos will show that.
That's
And there is a
another request
complete
I'd like to make. I'd like to
video
make that you
record.
retain those videos, but be able to sustain this issue, so all the
They've already
videos,
been posted, absolutely, you've got
Yeah,
access
but
to
make
them.
copies available to the
I
town.
just don't think this board, I believe that we may be tough on occasion, but we're not hostile to Pinnacle. We are trying to undertake our obligation under the law to behave in certain ways.
Well, this board, frankly, needs to address the 5 criteria, weigh it, and make a decision, that's all, it's a quasi-judicial function.
Mm-hmm.
Requesting, and certainly Pinnacle tried to accommodate requests for additional information, which again, we were very upfront, wasn't necessarily proper requests or within the scope of the variance request in front of the board. We accommodated, I think it was very clear in the rehearing request, which speaks for itself in terms of how that then request for information appeared to get manipulated. So it's an appearance issue. It may or may not have been intended, but there certainly seemed to be a predisposition and a harsher interpretation of certain zoning requirements. I heard this evening, oh, well, that's an intermittent stream, that's okay. And yet there was very specific planning board-like review of certain drainage issues and whether runoff, sort of into a ditch, whether the ditch is a stream and whether it qualifies. So there was some, what seemed to be more specific and targeted discussion in an effort to set up a reason to deny, if you will. And those were the types of things that we thought by having, again, requesting a rehearing, pointing out the points of error that we observed, we get to a new hearing, we clear the deck, and we put the proposal forth anew.
I think that you may have gotten the impression that we might have been very rigorous. But we were not, if we were, and that's entirely possible, we were looking at the other side of the coin.
absolutely.
So that's why we wanted to get all of the information that we wanted. The comment about the intermittent stream is personal knowledge on my part, and perhaps several others of the board. And I understand that your concern over my not being terribly rigorous about that. However, I think we could have done that if we didn't have the threat from the other side of the coin, that we were going to be
Understanding, right,
taken
there's
to
going to be
court.
litigation one way or the
Yeah,
other. And I
exactly.
understand it puts the board in the middle, but the
Right.
board's got to
Which is-
do its, right.
Which is why we were being so nitpicky when
Right.
we were.
But when there is an engineer saying, these are the calculations, an expert, if you will, and a butter or the threat of litigation, I mean, again, the case law says you gotta accept the unopposed testimony of the expert unless you've got specific, local knowledge that refutes that. So I understand the tough spot the board's in when there's gonna be litigation
You
one way
are
or the other.
talking with 3 engineers on the board.
Right,
Who
Well-
have understanding of local conditions.
right, but when, again, talking about drainage ditches versus streams, that's a definitional issue, whether it's governed by the zoning ordinance, that's not an interpretation. So that's just one example.
Okay.
Well, I mean, we get into the whole stream classification system, navigable waters of the United States, wetland delineation, et cetera, et cetera, et cetera, et cetera, et cetera.
Yeah.
Okay, I think we've talked about that. I have a couple, and I'd like to know if other members of the board have them too. One's question, a specific one. Your application makes use of the concept of workforce housing. Your application also, I believe, states that this is to be an intentional community.
Yes,
Does the intentional community, does it a requirement of accepting workforce housing that a person accept the tenants of the intentional community?
and is this question have we started the rehearing, or are we having an informal discussion? And maybe that's the best way
Wait
to,
on that one.
Okay,
I'm
we'll
having-
wait. We'll wait,
I'm having a problem with
we'll wait,
what
we'll
we're
wait.
doing here
Okay,
today.
we are accepting testimony from you as the beginning of the rehearing.
Are we in agreement on the rules going?
We
forward?
voted them.
I know we did, but is the applicant in agreement?
Are you in agreement?
That we,
If not,
the
please-
question is specifically that we bring all of the prior record forward by reference, not knowing at this moment which of those elements will be germane after we've gotten through reading your document. Do you have a problem with incorporating everything that's gone before?
I don't think I can agree to the wholesale reintroduction of the old record, because certain bits of that record were proposed by individuals who aren't here. So it becomes, again, as I tried to say, an evidentiary issue. I mean, these aren't hearings, but this record does go up and things are in evidence, so, without having a mechanism to know what the board is relying on, and then having the chance to,
But I've stated specifically,
rebut.
Bobby, that we
Right,
would
that's
bring
the-
those materials to you and put them on the table.
And they'll all be pieces of paper.
All be pieces of paper.
And you may very well disagree with their relevance, and that's.
That's
part
your
of the game.
privilege.
I
That's part
would
of the
make
game.
one exception. I think the other thing that may come in is the minutes of meetings.
Well,
Because there
there's-
will have been testimony
But
that's
there's still
verbal.
pieces of paper.
I mean, just so we're not, it's not just.
yeah, I don't know that it's for me to agree to a
I
procedure.
don't think it is.
I don't think it is.
Well,
And so maybe the issue is, again, I'm unclear, I've been, like I said, I've been told two different ways. Either the old record, I can't rely on it without resubmitting it,
We're talking
or
about
people.
basically
Right.
having available to us the old record in its entirety, but if we wish to make a part of that record a current finding, we put it on the table. That,
What I'm
It
really trying,
seems to make sense.
what I was trying to ask in another way, without
Yeah.
knowing what's new and what's prior.
Nothing is new in there. It's just reorganized in a way that frankly, we feel the old hearings got
I understand.
a little
And
meandering.
there was a lot of
Right.
lovely stuff that wasn't germane to the final decision, I understand.
Right.
So
Yes.
my only question there, reason for asking it and asking it in as broad a way as I could, is that, we don't know at the moment which of those things would be helpful in a new decision memorandum that may or may not be in here. I just would like the opportunity, without contention before the fact, that whatever was submitted and brought forward as part of the old record that we relied on to make our prior decision would be
Available
available
to you, yes.
to, and you'd have no, there's nothing that you submitted or others that submitted on your behalf. You would say, well, no, that's no longer,
Right.
okay, all right.
Question to the chair, and this is open. I will not be surprised to see us spend some considerable time on this matter. So what is
You
our
think?
thinking about the schedule?
And if I may, my intent would be to spend as little time, I mean, our intent in making a new notebook today was to summarize, boil down the prior however many hearings and get to the essence of the variance request, the 3 variance requests that were here, boiling it down to that, getting rid, so that we are not anticipating this to be a long drawn-out process.
With all
To the
due
extent
respect,
that we can help focus it in.
with all due respect, Bobby, you challenged us on virtually every point. So it seems to me that we're gonna have to consider a fair amount of material, and I don't think it's going to be a short
I
process.
don't either.
That's my take on it.
The, you made no, I'm asking the question, it has probably nothing to do with the hearing, it's, you had no progress with the planning board. You have not yet submitted that plan that you submitted to us, to the planning board
No, the
for site
discussions
plan,
with the.
for site plan review. or-
We can't submit it to the planning board for site plan review because it needs variances. So we're here first, under your ordinance.
Okay.
What the work that's been done, because your ordinance says if you need variances, you gotta come here first. So we can't submit it to the planning board. With the work that's been done with the planning board, they met in June, July, and again last week. Last week, was to work on ideas for a rezoning proposal that would allow tweaks to the zoning ordinance that
Mhm.
would remove the need for these variances and allow some form of this plan
Mhm.
to work. And that's where it's been difficult, because the planning board has indicated, come to us with something, but there hasn't been a lot of guidance in terms of what might have been acceptable. So, I think we're at the point where a proposal is being, we've had Jonathan work on things, and a proposal is being put together to submit to the planning board to get some input on what do you think, once again, if we tweak the zoning ordinance and put it up for town meeting, for a vote in March.
I mean, if it would be helpful, I can give a minute and David can address it, but the last planning board meeting, the third one, we asked a series of very specific questions and got what we thought was some very useful, specific information. And based on that, we have a draft, we have language which we will send, here's what we'd like, here's some variations, which hopefully will be discussed, at least initially, on December 10th, I believe is the next meeting. Because they're only meeting once a month because of the holidays.
And you don't have any time after the holidays, beginning of the planning process.
Well, we had hoped, of course, that the June and July meetings would generate this, but the planning board
Well, what's your
had a
cutoff?
different view.
Liz,
Well,
what's your
I
cutoff
take a little
date?
exception to that, Liz,
Okay.
because you had questions for the planning board. The planning board talked about the answers to those questions, and you left saying, okay, well, we'll mull this over and think about it, and then did not come back to the planning board until last week. So there was several months
Well,
of,
we did try and come back in October, but they were busy.
Well,
Right,
yeah.
between July and October, the consultants were trying to read
and
and
then,
tweak and give some specifics, because the planning board was not, I mean, they're familiar with this project too, and they're familiar with the ordinance. And so there was plenty of opportunity
Okay.
for people to provide some direction.
What's your deadline for a warrant article?
That's what I was
I think
thinking
it's
of.
December 9th, actually.
yes,
Yeah,
it is
that's,
December
that's
9th.
my feeling is.
So the warrant article,
Or
unfortunately.
for a
they-
petition warrant article.
Petition warrant article, which is not what Pinnacles wanted to do. They'd like to see the planning board participate in one of their own. That was
What's
the
their
effort.
deadline?
Their deadline is, they can do it in January.
They can do it in January.
Right.
Knowing this planning board and taking this whole project aside,
Yes.
the planning board does discuss things at length. And even minor changes, minor changes that are going forward have taken almost all year to get through. So, knowing this planning board trying to rush something through in a month, I think they're going to be very hesitant, because they will want to look at not only what the change is, but where it affects other places in the ordinance.
Right, it's gonna time out for this round, and that's why I think it was, I'll say this, it's disappointing that the June and July meetings didn't
So
focus
are you
in on
planning to
that.
put, and I think this is somewhat relevant to
Well,
our
let's-
discussions, are you planning to put in a petitioned article?
I think that's where we're going now, yes.
Okay.
For the planning board's consideration, and again, you put forth a petitioned article so that maybe the planning board can tweak it, you know, come to some agreement, we're not trying to go our own way, but the
Yeah.
process has been
No,
slow.
I understand.
Yeah,
Now, you will have to submit that before the planning board meeting.
on the tenth,
Right.
Right.
absolutely.
Yeah.
But I didn't expect that there wouldn't be, there'd only be one meeting. I mean, I understand that the holidays made it hard to
Okay,
meet.
so we need to then deal, our next task is as a schedule. And whether or not we try to do this at regular meetings. No, no.
No.
What?
Yes.
Yes,
And I guess,
there's no activity in December, January, February, not much, let's do it at the
Do you
regular
have anything
meetings.
coming up?
I have nothing else coming up that's.
Okay.
Let's try to do it at regular meetings, it's a little more humane. And we have a
I'll
lot of
only throw-
homework to do.
If this is going to be an exercise, and I'm just going to say this, it's going to be an exercise to step through this record to arrive at the same decision, then I don't know that we have to belabor the point.
We have no idea, and it would be prejudicial for us to make any comment that indicated that that was going to be the course. I mean, I think, Bobby, we've been told that we have to be very careful what we say in public,
Yes,
and so we're gonna go very slowly, and we're gonna do it very publicly. This is gonna drag on for a long time.
I think we said it in a prior meeting, publicly, I said it, which was, I was surprised when I read the request, how many points I thought we actually didn't do a very good job addressing. I'm not sure whether, if we press them again, we're gonna change our mind, but there was certainly an indication that, whoops, that must, we didn't do a very good
No,
job.
I think we can improve,
So.
but I don't know what those conclusions will be.
From my point of view, we have to look at your critique
Yeah,
and, all right, we'll look at it again.
we'll move from there, but I think, given the fact that because of the way in which language is treated, this is how we're gonna have to do it. And this may involve several of us sitting here with a computer writing out a finding, a fact. And we don't necessarily have to have as many findings as we did the last time, but the basic factual basis for our decision is going to take time and effort. Does this make sense to all of you?
Is there anything in the statute or that, what's it, time,
No,
we have to decide what it is?
not that I'm aware of.
You're not aware of any, are you?
So I move that the hearing, I'd like to move the hearing be continued to the next regular meeting in December.
I have one more question.
Certainly will.
You said, somebody said, he said, and you said, David and Bobby. Yes. I don't know your name, sorry.
Yes.
That variances are required prior to site plan review.
Yes,
And you said it's in our ordinance.
yes.
So I'm part of the site plan review regulations.
Says if we need, right,
Oh,
No, it's not in our ordinance, in the site plan review.
It's in site plan.
site plan
So
review.
if
It
the
says if
planning
you
board won't
know
accept
you
the
need,
site
right.
plan review application, it'll be considered incomplete if
Right.
it's submitted without zoning board approvals for anything that is needed.
And
Right,
how
when
do
you
they,
have-
how does the planning board know that?
They will review an application, they receive an application, and the first thing they do is they sit down at a meeting, review that application, go through everything in the application, they have a checklist, makes sure that everything is correct and there, and then they rule on whether it is complete or not. If it's complete, then they can go into a public hearing for the application. If it's not, they send it back to the applicant to.
Are they relying on their own judgment whether or not the application requires a variance or a special exception?
Yes.
Interesting.
Yeah,
The
that's,
regulation, right,
Yeah, but-
sends us out first, and it says if you know you need relief, you must go to zoning board first.
what regulation?
It was site plan review.
Site plan review.
Site plan
Yeah.
review.
And so we did, however, at David's suggestion, go to the planning board first for a conceptual.
Sure.
We couldn't submit a site plan because we knew
Yeah.
we had to come here. So we went in for the
Right.
conceptual, and the intent of that meeting was to ask the planning board, these are the variances we think we need and the special exceptions. Do you see anything else? We're going to the zoning board, so you guys let us know we've got it all, so we can do it all together. We never got that feedback from the planning board. What we got was a very negative reaction to the proposal, and we got what you got, which were the minutes, which was their position paper as to why we shouldn't get the variances we requested. But we never got any identification of
It
any,
was very helpful for them to do our job.
yes, it was, yes.
Well, the
It
question-
started the whole thing.
The question I have is, if you require variances in order to go to the planning board, it seems to me you need to have concrete plans in place, because the data, the issues that are being raised here are site-specific, particularly site-specific.
good share of them.
Because they relate to
Building coverage, sure.
building
And those are
coverage, the
calculations
topology,
that-
all the stuff.
Sure.
Everything is basically site plan review stuff. So the zoning board looks at what you submit, and I'm talking abstractly,
Yeah.
but the zoning board looks at what you submit, and suppose, based on what you've submitted, we grant all the variances. Now you have all the variances, you go to the planning board, and the planning board looks at your site plan and says, no, we're not gonna accept that because of this, and this. We want you to change this.
Right.
And for reasons unbeknownst to anybody, you accept those and then come back.
Mhm.
Now you have to come back to the zoning board for variances,
Possibly, yes.
changed variances,
Possibly,
which,
yes.
which have altered.
Or they could say, in their own view, that we didn't do the right thing granting the variances. They could say it was insufficient.
Well,
Yeah, they
my-
have to accept them.
But my,
But if they have a site plan reason, right?
Yeah,
Site
they
plan
can
reason,
change, yeah.
Drainage,
So-
traffic, whatever,
so-
yeah,
move that,
right.
you know,
what I
then,
don't, and
yes.
what I don't like about the process and what I don't understand is the fact that we're put in a position of doing a site plan review without the authority or the experience of doing site plan reviews in order to make judgments about the variances, in my opinion.
Technically, these variances involve less, I mean, again, building coverage. It involves less than all the things that site plan review is, and I think that's part of the, I mean, variances are usually done without fully engineered plans, only to the degree you know if you're in the setback. Our building coverage,
Sure,
one
but
of
this
our
is-
variances is, you know, is the walkway that connects to 7,000 square foot
Sure,
maximum
but there's some
buildings.
extraordinary issues that deal with the whole fabric of our zoning ordinance.
Yeah.
You understand that because, well,
That's our view.
I would argue with you.
I think
Right.
the intent is to actually prevent bouncing back and forth between boards.
Right.
Going to site plan review, presenting a site plan, having the planning board say, well, you know, here you need this variance, this variance, this variance, this variance. You go back to the zoning board, get all that, then go back to the planning board.
But in many cases, in this particular application, the authority for doing some of the things that are being requested lies with the planning
Planning
board
board.
in terms of numbers of buildings, numbers of structures, changing, you know, delineating dimensional stuff and things like that.
Not according to your zoning ordinance though. I mean, for example, the lot coverage is 26,000 square feet per lot. If we subdivide it into 4 or 5 lots, it's 26,000 on each of those lots.
No, I mean,
Our request
I'm-
here is for 58 instead of 26.
no, but I mean before that, it says
Yeah.
that it's the planning board that has the authority to set lot size, and
We don't.
we don't.
Right, but we're asking for a variance from lot coverage. That's not setting lot size.
Okay, so-
Right, so,
Well, we're talking past each other at this
Yeah.
time.
So I propose we decided to, have we in fact voted?
No.
No, okay.
When is the next meeting?
December 17th.
I move we continue to December 17th.
That's a Thursday.
It's generally speaking Thursday.
she's happy to bring us.
I do.
Two-
And if it turns out that for some reason Pinnacle Project members or attorney can't make it, we would then open them, have request a continuance till January.
Can I get with Dave about the large plans, so we can clarify for you which and what is gonna be on the table here?
Sure.
Is that,
I don't see.
I have a list of to-do items, so I just wanna make sure.
No problem.
Sure.
I'm doing what I need to do. The Conservation Commission report, I'll check with you about that.
Yep.
Okay. So that we will be given that at the next meeting?
Do you want to give new copies or reference the copies that they should already have?
Why don't we pull a new copy?
I would think that's good. AutoCAD has this distressing tendency to shift all the time.
Colors, you mean?
Not only colors, but because you keep modifying your preliminaries.
And
No.
if there is a discussion with town council, I would only offer that town council can call me if we wanna talk about the procedural issue of all in or all out. I've had those discussions with town council.
Other town councils?
Yeah.
I
Yeah.
can see no objection to
I
that.
have
It's
no
a-
objection to that.
It's a,
Now, can we get a binder for town council?
Maybe a binder.
One of these.
Oh,
We have.
I have, yes, I have one that I took.
Oh, delightful.
Thanks, Chris.
and you have all the old ones.
Yeah.
Yeah. So the only other matters which we're likely to bring in, I mean, are some site maps, some detailed maps of adjacent properties, which I believe you have copies of already. And I think that, public comment ought to be part of the record.
And those maps were ones provided by butters,
That's
correct?
correct.
Yeah.
Yeah. Yeah. You definitely should see those, yes.
Yeah.
Where the public comment was not, was verbally offered, I assume some of that's.
Right.
I would assume the minutes would be, sir.
We need a second on the motion.
So what do we do? Do I hear a second on the motion to continue? All in favor?
Aye.
Good, so moved. Okay. I move we adjourn, gentlemen. Do I hear a second?
Second.
I see a hand up there, Bill.
I'm ready to go.
It's going so slow.
You're in.